This week on Legal Talk with Hahn and Hahn attorneys, we are discussing unilateral change to terms and conditions of employment. For example, if you're in a situation like this where your employer changed the terms and conditions without your knowledge. So what should you do? We welcome Olebogeng Mangena from Hahn and Hahn. Welcome to Legal Talk, Olebogeng.
Thank you, man. Thank you for having me.
So, what do we mean by terms and conditions of employment?
Okay, the terms and conditions of employment would refer to the things such as the type of work that the employee is employed for, the place of work, the working hours, defining the salaries and wages, and also the leave that the employee is entitled to. So the terms and conditions of that employment would need to be given to an employee in writing, either in a contract of employment or in a form of a written particulars of employment. This may also be included in the collective agreements concluded between the trade union and the employer.
Okay, and what should then constitute a valid contract of employment?
So generally, a contract is any written agreement which details in an expressed or implied form how the parties are going to treat each other. So the general requirements of a contract are applicable to contracts of employment, such as the meeting of the minds between the employer and the employee, and that the employee must be of the legal age to conclude such contracts. So all the general requirements of a contract that are applicable to any other contract are also applicable to this one of employment.
Okay, and when do unilateral changes to terms and conditions of employment occur?
So under common law, an employer may not unilaterally change the terms and conditions of employment of an employee. Instead, a process of consultation should be placed between the employee or the affected parties in an attempt to reach an agreement on the proposed changes. And the prohibition on variation includes a lowering of the status of an employee and the provisions of terms and conditions of work that are substantially less favorable to that the employee had enjoyed previously. So that would include the method of performing work, would also amount to unilateral variation of employment.
And how can changes be fairly made?
In terms of the Basic Conditions of Employment Act, a collective agreement concluded in a bargaining council may be altered or replaced or excluded basic conditions of employment that are inconsistent with the purpose of the Act, which exclusion would govern the ordinary working time, the night hours, the maternity leave, sick leaves, and also child labor. So where an employer can justify the need to change the terms and conditions, and despite consultation with the affected parties or their representative, no agreement is reached, then the employer may exercise its right to engage in consultation towards possible retrenchments. But I must highlight that retrenchment should be a measure of last resort.
And then our final question for today: what remedial measures are available to employees who find themselves in this position?
If the affected employee is an employee who form part of a trade union, such registered trade union may refer the matter of the unilateral changes to the terms and conditions of employment to CCMA or a bargaining council for conciliation. And the trade union, through its referral, may give the employer a 48-hour ultimatum to comply with the demand that is not implemented, not to implement the changes, or where these have been implemented to restore the terms and conditions as they were before the changes were made. And also, the affected person may also refer the matter to the Labour Court for relief.
That was very interesting, Olebogeng. Thank you so much. That's it for this week's Legal Talk.
All right, thank you for having me.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.